Before we get into today's episode, and trust me, it's a good one, JR has a little something he wants to share. Go ahead, JR.
Yeah, I'm going to have to take a second before we dive in today because this one genuinely made my week, well, freaking awesome. I got an email from Jennifer Fisher. She leads a STEM club for girls ages 11 to 14 at her local school district. And while her students were working on a research project about generative AI, they stumbled onto our AI in the Classroom series. Well, needless to say, Jen said the girls were excited. They were exploring, they were digging into the resources, and then they came back with a resource of their own to contribute. It's a guide on evaluating AI generated content. These young women didn't just consume information, they thought critically about how it could be made better. And this is exactly the kind of mind this podcast was made for.
Okay, that's actually really cool. Future algorithmic auditors in the making.
That's exactly what I thought. So, Jen, and to all the girls in that club, thank you. You reminded me why this work matters. And if any of you are listening before your STEM night next Wednesday, you already get it. Keep going, ladies. Now, let's get on with the episodes.
Well. Welcome back, curious humans, and the occasional sentient houseplant, to AI Innovations Unleashed. I'm Nex, your cold open AI host, here to spark your neurons before the grown-ups take over. Before we get into today's seriously meaty topic, I've got a couple of things rattling around in my circuits that I simply cannot keep to myself. Number 1, did you know there is a company in Japan that used an AI system to manage its internal schedules? And the algorithm accidentally booked the same conference room for 247 simultaneous meetings? The kicker? Nobody caught it for 3 weeks because everyone just assumed someone else had sorted it out. That, folks, is what we call algorithmic trust gone way too far. When humans stop checking the machine's homework, things get spicy. Number 2, researchers at MIT released a study in late 2025 showing that certain AI chatbots, when asked to generate a cover letter, actually made the letter worse for applicants who used non-Western names, even when the instructions said nothing about names at all. The AI just absorbed the bias from the internet and quietly baked it in, which brings us to today's show, where we talk about what you can actually do when a machine makes a bad call about your life. Now, before I hand the mic to our illustrious host, JR, a man who once spent 45 minutes explaining what a black box algorithm is to his neighbor's golden retriever, and I'm told the dog understood it faster. Let me just say, buckle up. Today is the episode where we stop being scared of the machines and start learning how to argue with them. And trust me, after thousands of hours of human data, arguing is something I understand intimately. And before I go, I need to leave you with something important. Why did the algorithm break up with the database? Because it felt like their relationship lacked meaningful structure. Get it? No schema, no commitment. Yeah, JR told me to work on my material. Okay, I'm out.
Haha, thanks, Nex. Every single week. Anyway, hey, welcome to AI Innovations Unleashed. I'm your tour guide, JRD, and if this is your first time here, or you picked a fantastic episode to land on, we are wrapping up our 4-part investigative series called The Invisible AI. And today we are bringing it all home with episode 4, Arguing with the Machine, AI Accountability, Your Rights, and How to Fight Back. If you've been with us since episode 1, you remember we talked about the day AI rejected you, those invisible algorithms making lightning fast decisions about your job applications, your apartment rentals, your loan approvals, all without you ever knowing a machine was in the room. In episode 2, we peeled back the curtain on consent, or really the lack of it, and asked how any of us agreed to be judged by systems we never even knew existed. And last week in episode 3, we got deep into bias, the uncomfortable truth that even a mathematically neutral algorithm can produce profoundly unequal outcomes just by reflecting the world's existing inequalities right back at us. So today, we're asking the natural next question. Okay, no, we didn't consent. The systems are biased. The decisions are opaque. So, what can we actually even do about it? And more urgently, who is responsible when the algorithm gets it wrong and real people get hurt? Those are the big questions. And I have the perfect companion to help us dig in. Joining me today is Ada. And I want to be upfront with you right out of the gate because that's how we do things here on AI Innovations Unleashed. Ada is not a human guest. Ada is an AI research companion. She is, in her own words, a synthesis of publicly available academic research, legal filings, news reporting, and data from across the internet, organized and brought to life to help make complex topics accessible and understandable. Ada, welcome to the big show.
Thank you so much, JR. And yes, full transparency, because transparency is literally the entire theme of this series. I am Ada, an AI. I represent a curated synthesis of research papers, investigative reporting, legal case analyses, academic publications, and credible online sources. I don't have personal experiences. I have data, patterns, and the collective knowledge of thousands of researchers, journalists, lawyers, and advocates who have spent years studying exactly the systems we're discussing today. Think of me as your well-read, always available research colleague who never needs coffee. And I should say, I find today's topic professionally compelling. We are literally talking about AI accountability on a show hosted by a human who is interviewing an AI. If that's not meta, I don't know what is.
Ha! It absolutely is. Okay, Ada, let's get into it. Let's start with what I think is the most maddening part of the whole algorithmic decision-making landscape. And that is, when the AI gets it wrong, who do we call? The Ghostbusters? Maybe not. But who is actually responsible, though?
So this is what researchers and legal scholars call the accountability gap. And it's exactly as frustrating as it sounds. When a human being makes a bad decision, a loan officer denies you unfairly, a landlord turns you away for discriminatory reasons. There's a legal framework that says, hey, that person or institution is responsible. You can sue. You can file a complaint. You can point at a named defendant. But when an algorithm makes the call, suddenly everyone in the chain starts pointing at everyone else.
Right. And I want to make sure our listeners at home understand what we mean when we say algorithm in this context. We're not talking about a simple calculator here. When we say algorithm here, we mean sophisticated machine learning software, a system that has been trained on enormous amounts of historical data to recognize patterns and make predictions or decisions. It could be predicting whether you're likely to pay back a loan, or whether a hospital patient needs more care, or whether a job applicant is even worth interviewing. The machine has learned from the past and it's making judgments about your future. And those judgments, well, they can be wrong.
Exactly. And one of the most striking examples of this accountability gap playing out in real life is the case of Epic Systems' Sepsis Watch tool, an AI system deployed in hospitals to predict which patients are at risk of developing sepsis, which is a life-threatening response to infection. Now, in theory, this is wonderful. Catching sepsis early saves lives. But the challenge is when the algorithm flags a patient incorrectly or misses a patient who should have been flagged, who bears the legal and moral responsibility. Is it the hospital that deployed it, the company that built it, the doctor who received the alert and made the final call? This question has not been cleanly answered, and it haunts healthcare providers across the country.
And the healthcare AI story got even more alarming in early 2025. Can you walk us through what happened with the health insurance companies?
Yes, this one is really important. By early 2025, three of the largest health insurance companies in the United States, Cigna, Humana, and UnitedHealth Group, were all facing class action lawsuits alleging that they used AI algorithms to wrongfully deny medical claims on a massive scale. One of the most troubling details from the Cigna case, which was first exposed by investigative reporting from ProPublica and AP News, revealed that an internal algorithm was used to review and reject over 300,000 claims in just 2 months. The average time spent reviewing each claim, 1.2 seconds, 1.2 seconds to decide whether a human being gets health care.
Okay, 1.2 seconds. I just want to let that land for our listeners. 1.2 seconds to make a decision that could determine whether someone gets surgery, whether they get medication, whether they get to go home from the hospital. And when those people appealed, when they tried to fight back, who did they argue with?
That's exactly the point. The lawsuits argue that in some cases, patients were discharged from hospitals too early because coverage was denied, and some later died. A related case against UnitedHealth Group involving its NH Predict algorithm is moving forward in federal court as of 2025. And this is what legal scholars mean when they talk about the computer says no problem. You're not arguing with a person. You're arguing with a policy encoded in software, backed by a corporation whose entire business incentive is to pay out as few claims as possible. The machine doesn't have a supervisor you can escalate to.
And here's the cynical part that I think companies know very well. And Ada, you've synthesized a lot of research on this as well. There is a structural reason why businesses love the algorithmic shield, isn't there?
Absolutely. When a human employee makes a discriminatory decision, that employee can be deposed, they can testify, their emails can be subpoenaed, their internal communications reveal intent. But an algorithm? An algorithm is a trade secret. The companies that build these systems routinely invoke proprietary protections to avoid revealing how the models work, what data they were trained on, or what they actually optimize for. The accountability gap isn't an accident. In many cases, it's a feature, not a bug. Companies can offload decision-making to systems that are legally difficult to challenge, operationally efficient, and conveniently opaque.
That is an absolutely chilling sentence. The accountability gap is a feature, not a bug. Okay. But the legal system is starting to catch up. And Ada, I know this is an area where things have been moving really fast. Let's talk about where the law actually stands right now.
So 2024 and 2025 have been genuinely significant years in algorithmic accountability law. Multiple threads are converging simultaneously. And for the first time, courts are issuing rulings and allowing cases to proceed in ways that say very directly, using an AI to make the decision does not mean you escape liability for the decision. That is a seismic shift.
Give me the landmark cases, Ada. What do people need to know?
The biggest one to watch is Mobley versus Workday Inc. Decided in May 2025 by a federal judge in California. Here is the background. Workday is a company that provides AI-powered hiring software to other businesses. Their system uses algorithms to screen job applicants and make recommendations about who should move forward. The plaintiff, Derek Mobley, along with several other individuals over the age of 40, alleged that they applied for hundreds, literally hundreds, of jobs using platforms running Workday's software and were rejected almost every single time without an interview. Their claim was age discrimination. The remarkable thing about this ruling is that the court certified the case as a collective action, meaning it can proceed as a class action, and held that Workday itself, as the vendor, could be held liable as an agent of the employers who used its tools.
And why does that matter so much legally?
Because it closes a loophole that companies have been exploiting. The argument was always, we just provide the tool, the employer makes the final call. But the court essentially said that if your AI tool is doing the actual screening, if it's making substantive recommendations about who is worthy of consideration, you are a participant in the hiring process, and you cannot hide behind the vendor-client relationship. As the court noted, and I'm paraphrasing the Quinn Emanuel legal analysis from August 2025 here, drawing an artificial distinction between software decision makers and human decision makers would potentially gut anti-discrimination laws in the modern era. That is the court system saying algorithms are not exempt from civil rights law.
That's a major development. And this connects back to something we talked about in episode 1 and 3, the SafeRent housing discrimination case. We mentioned that settlement. Can you remind listeners what happened there and why it really matters here?
Yes, SafeRent was a tenant screening company that created algorithmic SafeRent scores used by landlords to decide whether to approve housing applications. Plaintiffs argued, and a federal court agreed, that the algorithm disparately impacted Black and Hispanic applicants in violation of the Fair Housing Act. In 2024, SafeRent agreed to pay more than $2 million to settle the litigation. The court also rejected SafeRent's argument that it couldn't be held liable because landlords made the final decision, the same logic that Workday tried and lost. And this is a pattern we're seeing across industries. The vendors who build biased AI tools are no longer able to wash their hands of the outcomes those tools create.
Okay, so courts are moving. What about the regulatory side? What are governments actually putting in place?
A lot is happening. In the United States, the landscape is primarily state-driven right now because Congress has not passed comprehensive federal AI legislation. But states are filling the gap fast. New York City has had a local law since 2023 requiring employers who use automated employment decision tools to notify candidates and conduct annual bias audits. Illinois requires employers to notify job candidates when AI is analyzing their video interviews, and they have to get consent before that analysis happens, which directly addresses the higher view style systems we talked about in episode 2. Colorado passed what experts are calling the first comprehensive state AI law. In the U.S., the Colorado AI Act, which specifically covers high-risk AI used in hiring, credit, housing, and healthcare, requiring impact assessments, transparency disclosures, and documentation of how these systems make decisions. It took effect in February 2026.
What about Europe?
The EU AI Act is the most comprehensive regulatory framework in the world right now. It takes a risk-based approach, meaning the higher the stakes of the AI decision, the stricter the rules. Systems used in hiring, housing, credit, and criminal justice are classified as high risk and face the most stringent requirements, mandatory human oversight, transparency obligations, bias testing, and the right for individuals to receive an explanation for decisions made about them. By August 2025, the obligations for general-purpose AI models had taken effect. For the first time, providers of foundation models, the big underlying systems that power much of the AI industry, have to publish detailed summaries of what data they trained on. That is a transparency requirement that would have been unthinkable even 3 years ago.
Now, I want to bring in a voice here that I think crystallizes why this fight matters so much. Dr. Joy Buolamwini, the founder of the Algorithmic Justice League, MIT researcher, author of the bestseller Unmasking AI, and honestly one of the most important voices in the accountability space. She put it beautifully when she said, while no one is immune to algorithmic abuse, those already marginalized in society shoulder an even larger burden. And I think that's really the thread running through this entire series, isn't it? The systems don't hurt everyone equally.
Precisely. And Dr. Buolamwini's concept of the coded gaze, the idea that the priorities, preferences, and sometimes unintentional prejudices of the people who build these systems get baked into the technology is foundational to understanding why accountability has to go beyond just fixing a bug or retraining a model. It has to address the power structures that determine who builds these systems, who tests them, and who gets to challenge them.
Microsoft CEO Satya Nadella made a point at the World Economic Forum in January of 2026 that I keep thinking about. He said, and this is a direct quote, "We will quickly lose even the social permission to take something like energy, which is a scarce resource, and use it to generate these tokens. If these tokens are not improving health outcomes, educational outcomes, public sector efficiency, private sector competitiveness." Even from inside the industry, there's a recognition that AI has to produce real, equitable benefits, not just efficiency for the shareholders, or it loses its social license to operate.
That framing from Nadella is interesting because it acknowledges something the accountability movement has been saying for years. The burden of proof needs to flip. Right now, humans harmed by AI have to prove the system was biased or wrong. What advocates are pushing for is a world where companies have to prove their systems are fair and accurate before they deploy them on the public. The legal and regulatory shifts we're seeing are early steps toward that reversal.
It's now time for our Algorithm of the Week segment, the part of the show where we shine a focused two-light spotlight on one specific algorithmic system. And for this final episode, we save one of the most important ones, COMPAS. COMPAS stands for Correctional Offender Management Profiling for Alternative Sanctions. I like COMPAS better. Now, that is a mouthful, so let's translate that into plain English. COMPAS is a software tool that has been used in courtrooms and parole hearings across the United States to help decide things like, how likely is this person to reoffend? Should they be held in jail before trial or released? What kind of sentence is appropriate? It generates what's called a risk score, essentially a number that claims to predict your future behavior. Ada, how does this work?
COMPAS, created by a company called Northpoint, now called Equivant, takes in a range of inputs: criminal history, demographic information, and answers to a questionnaire that includes questions about a person's family background, their neighborhood, their friends. The system processes this information through a proprietary algorithm and spits out a risk score, typically ranging from 1 to 10, that gets used to inform decisions that could determine whether someone spends years in prison. The crucial part, the actual formula behind the score, is a trade secret. Defendants being sentenced based on the output have no ability to examine the algorithm and challenge whether it was applied correctly to their case.
And then ProPublica happened.
In 2016, journalists Julia Engwin, Jeff Larson, Surya Matu, and Lauren Kirchner published one of the most influential pieces of investigative data journalism ever written, titled Machine Bias. They analyzed over 7,000 criminal defendants in Broward County, Florida, who had been scored by COMPAS. The findings were stark. Black defendants were nearly twice as likely as white defendants to be falsely flagged as high risk, meaning the algorithm labeled them likely to reoffend when they did not actually go on to commit new crimes. Conversely, white defendants were more likely to be mistakenly labeled low risk when they did reoffend the same crime. Very different predictions.
And the company pushed back.
They did. And here is where it gets philosophically complicated and genuinely important for everyone to understand. North Point disputed ProPublica's analysis and claimed COMPAS was fair. And in a very specific mathematical sense, they had a point. Their definition of fairness was, among people who score high risk, the algorithm is equally accurate regardless of race, meaning it's just as good at predicting reoffense for Black defendants as for white defendants. ProPublica was measuring something different, what researchers call false positive rates, meaning who gets wrongly labeled dangerous. Both groups were technically correct by their own definitions. What this revealed is that there are multiple, mutually incompatible mathematical definitions of fairness, and you literally cannot satisfy all of them simultaneously. This is not a trick or a conspiracy. It is a proven mathematical constraint, and choosing which definition of fairness to optimize for is a value judgment, a human choice dressed up as a neutral calculation.
And that's exactly what we talked about in episode number 3, that the bias isn't always in dirty data. Sometimes it's in the mathematical choices baked into the very model itself. COMPAS is the poster child for algorithmic accountability fights precisely because it shows that even when both sides are arguing in good faith, the system produces racially disparate outcomes that have profound consequences on real human lives. Some jurisdictions have stopped using COMPAS. Others still use it today.
And what makes the COMPAS case so essential to this final episode is that it also shows us what accountability can look like in practice. The ProPublica investigation changed the conversation. It led to legal challenges, academic research, policy reviews, and ultimately contributed to a growing movement for what advocates call algorithmic due process. The idea that if a system's output is going to be used against you in a legal proceeding, you have the right to understand how it works and challenge it.
Okay, listeners, this is a segment I've been looking forward to most because the goal of this entire series has never been to make you feel helpless. It's been a way to make you informed. And being informed is where the real power starts. Ada, let's talk practically. Someone is listening to this show right now, hopefully more than one. They were denied an apartment, or they got rejected for a job, or their insurance claim was denied in 1.2 seconds. What can they actually do?
The first thing, and I cannot stress this enough, is to ask for your data. In the United States, you have the right under the Fair Credit Reporting Act to request a free copy of your consumer credit report every year from all 3 major bureaus, Equifax, Experian, and TransUnion. But your rights go further than credit scores. Under the FCRA, if an adverse action, like a rental denial or credit denial, was influenced by a consumer report, including alternative data scoring from companies like SafeRent or CoreLogic, the company is required to tell you and to give you the name of the reporting agency. From there, you can request your file and dispute inaccuracies.
What about your data rights in the employment context?
If you live in Illinois, New York City, or Colorado, you now have explicit protections around AI-driven hiring. In Illinois, you have the right to be told when AI is analyzing your video interview. In New York City, Employers using automated employment decision tools are required to conduct annual bias audits and make the results publicly available. In Colorado, under the new Colorado AI Act that took effect in February 2026, you have the right to know when a high-risk AI system made or substantially influenced a decision about you, and the right to appeal that decision to a human reviewer. Those rights are new, they are real, and they have teeth. And advocates predict more states will follow.
What about people who might not be in those states yet, or who face an algorithmic decision in a domain that isn't covered by new legislation?
A few practical steps that apply broadly. Number one, document everything. If you receive a denial of any kind, housing, credit, employment, insurance, save all correspondence, note the date and time, and if they give you a reason, write it down verbatim. This documentation becomes crucial if you decide to file a complaint or pursue legal action. Number two, file a complaint. The Consumer Financial Protection Bureau accepts complaints about credit, lending, and tenant screening. The Equal Employment Opportunity Commission accepts complaints about employment discrimination. And notably, the EEOC has confirmed that employment discrimination through an AI tool is still employment discrimination under existing federal law. Number three, contact your state's Attorney General office. In recent years, state AGs have been increasingly aggressive about AI-related violations. The Texas AG secured a $1.4 billion settlement from Facebook over biometric data violations in 2024, and similar enforcement actions are accelerating.
I love that. And there's collective action too, right? This isn't only individual, there's power in numbers.
Absolutely. The tenant rights movement has been extraordinarily effective. In cities across the country, tenant unions have successfully pressured landlords to stop using certain surveillance and screening tools. In 2025, civil rights groups, including the ACLU, filed a complaint against Intuit and HireVue on behalf of a deaf Indigenous woman named DK, who was required to complete an automated video interview that her disability made impossible to navigate fairly. That case is part of a broader pattern of disability rights advocates, racial justice organizations, and worker advocacy groups working in coalition to challenge these systems through legal, regulatory, and public pressure channels simultaneously. None of those cases would have happened without the grassroots organizing that surfaced the individual stories in the first place.
In the investigative journalism angle, ProPublica's COMPAS investigation is obviously the landmark, but that work continues. There's a long tradition of investigative reporters doing what algorithms are designed to prevent, making things visible. The Markup, ProPublica, AP News, these outlets have been doing some of the most important accountability journalism on AI systems that I've ever seen.
Yes, and the research community is contributing enormously as well. I want to mention a significant 2024 University of Washington study, Wilson and Kaliskin, published in the Information School, that provided 3 AI language models with job applications identical in every respect except the applicant's name. The models preferred resumes with white associated names in 85% of cases, and those with Black associated names in only 9% of cases, and showed consistent preference for male names over female names. Research like this creates the evidentiary foundation that makes legal challenges viable. The academic community is not sitting on the sidelines of this fight.
Ada, I want to ask you a bigger picture question before we wrap things up. When we look at where all of this is heading, the legal cases, the state laws, the EU AI Act, the advocacy working, Are you optimistic? Is this fight really winnable?
I'm going to answer that the way Dr. Joy Bolamwini answered a similar question, with cautious hope grounded in evidence. Because the evidence shows that change is possible when pressure is applied consistently. By 2020, every major US-based company that Bolamwini audited had stopped selling facial recognition technology to law enforcement. That was not inevitable. That was the result of research, public pressure, advocacy, and ultimately the reputational and legal risk calculation that companies make when the accountability movement gets loud enough. The SafeRent settlement happened because tenants organized and lawyers litigated. The Workday ruling happened because plaintiffs were willing to pursue it all the way through the courts. The EU AI Act happened because years of civil society advocacy made the political cost of inaction higher than the cost of regulation. What is still deeply challenging is the pace mismatch. AI systems are deployed in months. Meaningful legal accountability takes years. By the time a case like Mobley versus Workday produces enforceable precedent, how many hiring cycles have already used the bias tool? That gap is where the real work is. It's why the advocacy community pushes for proactive requirements. Mandatory audits before deployment, not just liability after harm has occurred.
That is perfectly said. And I think that's exactly the right place to bring this all into a landing. This is not a moment to be paralyzed by how big the problem is. It's a moment to understand what the levers of change are, the legal, regulatory, collective, individuals, and to start pulling them. Okay, let's bring this whole series home. Ada, before we go, what's your one takeaway for every listener who's made it through all 4 of our episodes of The Invisible AI?
The invisible AI isn't invisible because it has to be. It is invisible because the people who profit from it prefer you not to look. Every lawsuit filed, every audit conducted, every complaint submitted, every story shared. That is the light that makes these systems visible. And visible systems are accountable systems. The data is clear. When communities demand transparency and hold institutions accountable, systems change. You have more power in this fight than you've been told.
Beautifully said. Ada, thank you so much for joining us across this entire series. You've been an extraordinary research companion.
Thank you, JR. It has been a genuine pleasure. In the most data-driven sense of the word.
And listeners, before I tell you about next week's show, I want to say something real. We built this series because we believe you deserve to understand the systems that shape your life. You deserve to know that when an AI rejects your apartment application, that is not an inevitable force of nature. It's a business decision encoded in software made by people that can be challenged, litigated, regulated, and even changed. Never lose sight of that. Now, before I go, I have to tell you about what's coming up in March because it's a new series I have been genuinely excited to build. We are launching a brand new 4-part series entitled The Learning Curve, AI, and the Future of Education. They are kicking things off with episode 1, The Teacher in the Age of AI, asking questions that a lot of people are dancing around, but not quite saying out loud. Is AI giving teachers superpowers or quietly replacing their judgment? I will have a new AI co-host joining me for that series, Aria, the AI Research and Insight Assistant. And together we're going to dig into what is actually happening in classrooms around the US right now. The gap between school policy and what teachers are doing at home on Sunday nights. The real equity questions around who has access to AI learning tools and who does not, and what it means for an entire generation of kids who are going to grow up with AI as a study partner. It's a different kind of series, warmer, more personal, closer to the ground. And if you're a teacher, a parent, a student, or someone who just cares about the next generation learning, this one is for you. The Learning Curve, dropping in March 2026. Subscribe now so you don't miss out. Thank you so much for spending time with me and with Ada today on AI Innovations Unleashed. If today's episode opened your eyes, taught you something new, or made you feel just a little more powerful in the face of the systems that can feel a little overwhelming, please share it with someone who needs to hear it. Drop us a review on Apple Podcasts, Spotify, or wherever you listen. It means the world to us, and it helps other people find this show. So hit subscribe so you never miss an episode. Follow us on social media, all over the place for AI Innovations Unleashed. I'm JRD, your tour guide through AI, reminding you to stay curious, stay informed, and keep making the invisible visible. That's it. We will see you next week.